Good evening. I'm Ingrid Chiemi Schroffner from the Asian American Lawyers Association of Massachusetts. How are you? Welcome to our first Asian Lawyers show on LegalLine. We have a call-in number, 617-973-4848, if you have questions for our guest. Our very first guest is Professor Carwina Weng from the Boston College Law School. She's an assistant clinical professor there. She's also the vice president of the Women's Bar Association and the founding co-chair of the Women of Color. Have I got that right?
Founding co-chair of the Women of Color Committee, yes.
Yes.
Thank you so much for inviting me to be here, Ingrid. I'm delighted to be here.
It's great to have you. And can you just tell us a little bit about your background?
Sure. I teach, as you said, at the Boston College Law School in the clinical program at the Boston College Legal Assistance Bureau. I've been in legal services practice in New York and Boston. And personally, I'm a Taiwanese American, although primarily raised here in the United States.
I see. And in your work, you've also been focusing a little bit on multiculturalism and the practice of law in different cultures. Isn't that right?
That's right. You'd have to say, really, as a woman of color in the United States and in legal services practice, where the clientele is very diverse, racially, ethnically, national origin, sexual orientation, all of it. We see everybody coming in through the door. Teaching lawyers to work with clients who are different from themselves is a huge part of our mission. So a lot of the work that I do as a clinical professor, including my scholarship, has been a multicultural lawyering. I
see. And do you have any recent publications or any upcoming publications?
Very kind of you to ask. One of each, as a matter of fact. This spring, I was very fortunate to publish in the Clinical Law Review my first article. It's called Multicultural Lawyering, Teaching Psychology to Develop Cultural Self-Awareness. And I am co-authoring an upcoming piece with another professor, colleague at Boston College, Paul Tremblay, which is called Multicultural Lawyering, Heuristics and Biases, which is forthcoming in a book edited by Marjorie Silver called Effective Assistance of Counsel.
Excellent. And once this is published, where could somebody obtain a copy of this book?
I think the easiest way for now would be to check with the Carolina Academic Press website. Once we have more information as well, I'd be happy to let AALAM know.
Excellent. Well, thank you. I just want to refer to the graphics screen. I believe we have a copy that Professor Wang has provided us with. There we are. Clinical Law Review. And can you tell us a little bit about some of the techniques that you try to imbue into your students?
Well, let me start with sort of defining what I think of as multicultural lawyering. Any interaction that we as lawyers have with clients who are from a different cultural group from us is a multicultural encounter. And what we're trying to do is to teach students to respect the client's cultural background, whether it seems similar at first glance to the lawyer's or clearly different. Because you can have expectations of the client, sometimes assumptions, sometimes biases and stereotypes, if you aren't familiar with the client's cultural group or if you think you're familiar with the client's cultural group. So what we do in class and with the articles that we talk about is how to prepare for these encounters, working more effectively with the client in order to better represent them either internally or to an external audience, whether it's a court, a transactional experience, negotiations with the other side, all of that.
Mm-hmm.
And what we say is there are three different areas that the student really needs to develop some competence in. The first is attitude, how we think about multicultural lawyering, whether it's important, how we think about culture, our own and our clients, as well as the legal culture in which we all function. Knowledge, what do we actually know about our own culture and the client's culture? And then skills. This is the one the students, of course, and lawyers also are most interested in. What do we actually do when we're confronted with a client who seems different from ourselves?
Mm-hmm. Well, when you're teaching this to your students, have you ever come across a criticism, perhaps, that this type of teaching is promoting stereotypes?
It hasn't come up directly, but that is obviously one of the fears. Actually, one of my colleagues who had written an article was presenting his paper at a conference, and some of the attorneys of color were very concerned that the first thing that an attorney would do would think, I've read this article, I know a lot about let's say, for example, a Taiwanese American and how they will react to lawyering. So I'm going to be an expert now. Mm-hmm. And the fear is that, in fact, foot and mouth or just a big mistake, the knowledge that they've gained will be stereotyped or won't actually apply to this particular client. Mm-hmm. And so they may end up making it an awkward situation instead of actually trying to be sensitive and non-judgmental encounter. Clearly, though, I think what students are more concerned about is not just stereotypes, but prejudice. Are they going to be seen as prejudice? Are we saying, in fact, accusing them, perhaps, of being biased when we teach them to respect other people's cultures through multicultural lawyering? And part of the concern, of course, with bias is that we will be buying into stereotype.
Mm-hmm.
Okay. What we do is to say, look, we're not accusing people of being prejudiced. And let's be careful with how we define prejudice. Prejudice occurs if you actually think that your own culture is superior to another culture's, or if you think that the stereotype that you've heard, the cultural images perhaps that you've learned about this other culture, are what define members of that culture. And to use some examples, we've probably all heard these as Asian Americans, we're all alike. Doesn't matter what part of Asia we come from, how long we've been in the United States.
Absolutely.
All Asians are the same. We don't speak English. We're slanty-eyed. We're stoic. We don't show any emotion. I talk a lot with my hands. I know that's not true for myself. And we're all foreigners. Okay. So if a student actually believes that to be true of a client they're working with and doesn't delve at all into the actual client's circumstances, background, effect on their legal case, then perhaps there is some prejudice that's involved. But what we're trying to do is to help them understand that an automatic reaction or an automatic assumption about a client as that might be stereotyped doesn't mean that the lawyer herself or himself is prejudiced, and doesn't mean that that's how they're actually going to lawyer for that client.
I see. And so when you are teaching your students and trying to steer clear of promoting stereotypes or beliefs that might already exist, what are some safeguards that you try to have your students keep in mind, or are there certain things that you try to emphasize to make sure that the point is getting across?
Some of it is to start with ourselves, to recognize, first of all, that lawyers, all of us, have culture. As I identify myself, first of all, as a Taiwanese American. That has a certain political ramification within Asian American cultures. Identifies me politically as someone different from someone who might say she's Chinese American. So start with yourself. What is your cultural identification? What are stereotypes that exist about your cultural identification, whether it's as a lawyer, as a woman, as a Bostonian? Okay. How might your client come in thinking about you then? Are there expectations or stereotypes they will have of us as well as that we will have of them? I think if we understand that we come to this lawyer-client relationship with our own culture, it makes it easier for us to recognize that the client has cultural issues also, and that we're trying to manage our culture, the client's culture, and the interaction of both of those together. And being aware of our own culture, I think, helps to foster respect and a non-judgmental attitude towards a culture that's different from ours. I
see. Well, looking at the upcoming publication, I note that the title uses the word heuristic, and it's Multicultural Lawyering, Heuristics and Biases.
Right.
Can you tell us a little bit about what a heuristic is?
Sure, at least in the context of this article. When we're trying to work with multicultural lawyering, it is so easy to fall into the trap of stereotypes. To think that because we know something about a culture, that's going to define everybody in the culture. A heuristic is a generalized inquiry. It's almost an approach to a problem. So we have developed, Paul Tremblay has identified 6 heuristics in multicultural lawyering. Areas that you as a lawyer can start to think about substantively, learning about the client's culture, so that you can anticipate better how to work with that client. And it's a heuristic because it's a starting point. It's an expectation, but it's not necessarily applicable to each client that you encounter. So Paul has said, look, for example, at body language. We all have body language. Like I said, I'm gesturing with my hands now. Most of us do in the United States. It's part of how we talk.
Sure.
Not every culture does that. How do you interpret the body language, though? Eye contact is one of those things. Do you make eye contact when you're talking, or do you look away? One thing you might learn as you're reading about Asian cultures is that they might not make eye contact. Okay. How do you read that? If you are an American, do you think, oh, my client isn't making eye contact with me. That means they're not telling me the truth. Whereas the client may be thinking, I'm being respectful by not looking you in the eye.
Sure.
Or I only make eye contact when I'm listening. When I'm talking, I'll look away. So A heuristic is, how do I start thinking about the eye contact so I'm prepared? Not to say that every single time my client makes eye contact or doesn't make eye contact, I'm going to judge credibility based on what I know, but to be prepared for a potentially different experience.
Yes, it seems to me that a client who doesn't make eye contact could come across in a light that is not necessarily beneficial to a judge and also maybe to the other side, or wouldn't perform well possibly in a deposition.
That's right. We're always telling our clients as they get ready for a trial or a deposition, look at the judge, make eye contact, because that's the expectation in the United States.
So if that were the case in a client-attorney relationship, what would you suggest would be a good way to address that problem?
Do you mean...
or actually, I shouldn't say the word problem, to address that mannerism.
Right. It depends on where we're addressing it. If an issue has come up between the lawyer and the client, the lawyer says, I'm not sure I trust what my client is saying me, we're going to explore why. Okay. We're also very lucky at BC to be able to videotape a lot of our client interviews. So we can actually go back and look at particular parts of the interview that the student has done and see if we can pinpoint why they think the client is not trustworthy. If it turns out that it's something around eye contact, for example, we can start talking about it. If then we're preparing for trial, and it is a primarily litigation-based clinic program, then we have to talk to the client. Okay. Here's going to be the expectation when you go into the courtroom. The judge will walk them through. This is what a courtroom looks like. Here's where you will likely sit or stand. This is where the judge is going to be. We don't tend to do a lot of jury trials, so it's usually looking at the judge. And we'll talk about that. What is the judge going to expect? What is the other side going to expect? Do you think you can do that? Not everybody's going to feel comfortable looking at the judge all the time. And if that's the case, what do we do to educate the judge?
Sure. Now, might there be some situations where actually implementing a stereotype might be beneficial to a client's case? Is that a possibility?
Probably. I hope that there aren't too many instances of it, but it certainly comes up.
I mean, I realize it's somewhat of a controversial question, but I'm just curious for our audience because, first there's a communication issue that might be a problem in a client-attorney relationship, but at the same time, attorneys are supposed to be advocates, and sometimes it's tough to know where to draw the line.
It is very hard. We don't necessarily want to be perpetuating stereotypes, but again, as you said, lawyers are zealous advocates for their clients. If it's going to help the client's case, should they make use of it? And my personal opinion is, if you think there's a stereotype that will help your client, you shouldn't assume that you can use it, especially if you are a lawyer who doesn't belong to that client's cultural group. It should be a conversation you have with the client. Is the client actually comfortable using that stereotype? It might not be how they feel. They should be viewed. And so many people think about our court system as the place to be heard, where justice, their day in court is really important. Do they want to go into their day in court being someone other than themselves? Sometimes, yes, absolutely. If they think that's going to help their case, they might want to take advantage of it. But do they want to potentially go into court based on some misrepresentation of who they are? They want to tell their story. Usually that
doesn't not necessarily a factual misrepresentation.
Not necessarily. Right? No, we wouldn't be wanting to lie or otherwise
of course
materially misrepresent our clients, but maybe not correcting things. Okay. If a client, I'm trying to think of an example here. I do a lot of family law cases, for example, and with domestic violence, perhaps. Is our client perhaps going to be seen more sympathetically if she is viewed, a woman client, as a submissive or quiet, non-troublemaking victim of domestic violence?
Sure.
Okay, she hasn't gone to the police because she's very concerned, because of Chinese culture, for example, that none of the family's dirty laundry get aired outside. So it would be wrong to disclose anything happening in the family, not just to her neighbors or to her extended family, but certainly not to the police. And so if there is no trail of police reports or anything, is that why? Maybe that's not it. But if that comes up as an assumption about her because she's a Chinese woman and Chinese women are considered quiet and submissive, would I bother to correct that? Or would I talk to the client about, here's what I think I'm seeing happening in court. Do we want to just let that sit?
I see. And I understand your answer is that your personal point of view is that really it's the client's choice because the client's hired you as the lawyer. So if you talk about it with the client makes the decision as to whether or not ethnicity should be part of the strategy, or a stereotype for that ethnicity should be a part of a strategy for court, or whether or not the attorney should explain to the judge and possibly to opposing counsel what some cultural norms are for that particular client.
Exactly. And I'm glad you said both ethnicity and stereotype, because they both come up. I mean, the client's ethnicity, her own identification with ethnicity, her sense of how she is functioning in American society is an issue. But does she want to make it an issue?
Sure.
And then does she want to deal with stereotypes, or rather with the very accurate depiction of an identification for herself as an ethnic American?
Well, that's interesting. So this approach to lawyering, this multicultural approach to lawyering, is this a relatively new field in your experience?
It is. It's been percolating, certainly, and it's getting a lot more scholarly attention now. I have to say, lawyers have been slower off the mark to recognize the importance of culture in lawyering than, say, doctors or social workers, psychotherapists, for example.
That's true. I noticed in the draft, at least for the upcoming publication, that there are references to a lot of rich literature on multicultural counseling in other areas than law, and you've sort of looked on that and tried to use it for legal counseling. And I found that interesting. I was wondering if you could tell us a little bit about what the difference is in being a lawyer versus these other fields of counseling that you've sort of taken some information from.
I can tell you the first reaction from the students usually is when we're talking about emotions as part of our lawyering work or multicultural considerations as part of our lawyering work, that's touchy-feely. We're here to be lawyers. We just want to know what the legal problem is, and we're going to do the legal analysis. I'm going to read the statute, I'm going to read the cases, and that'll take care of the problem, right? So that's the first reaction. And I do think that helps to define the difference between lawyering as a profession and psychotherapy or other kinds of service professions. Social scientists and psychologists have long, I think, recognized that culture is part of every interaction that we have. And we don't just mean by culture ethnicity, race, national origin, but gender, obviously, socioeconomic class, education background, work status, birth order. I mean, as, again, someone from a Chinese culture, birth order is very important. Where's that son, for example? I may be the second in my family, but my brother is the number one son and the only son, and the expectations of him, even though he's the youngest of the family, are different because he's the oldest son. So that affects all of our cultural complications as well. Oops, I see we have a call.
I see we have a call. Hello. You're on LegalLine with the Asian American Lawyers Association. Our guest, Carwina Weng.
Hi, I just have a question. I purchased a car actually in April, and I'm just having a little bit of problems with my vehicle. Like, I've just been having numerous problems. I just wanted to know, what kind of lawyer can I talk to regarding this problem? Like, is there a lawyer that deals, especially like in auto sales, or, you know what I'm saying? Like, I just wanted to know, where can I be directed to talk to someone to get this case going?
I'd suggest actually the Attorney General's office. I don't know the number for that offhand, but if you have access to the phone book or the internet, they have a very good website with a lot of consumer advice. And I think if there is, in fact, a complaint that needs to be made, there are forms that you can download on the site that would help you to seek redress.
Okay, and what is that website?
I don't know the website's address, but it's the Massachusetts Attorney General's office.
Okay. All right, thank you so much for your help. Thank you.
Good luck.
Thanks, bye-bye.
Thank you.
You're welcome. Again, as I said, being in legal services practice, we cover a lot of different areas. But you were asking, again, about the differences. The social scientists, like social workers, going through school are required to learn about multicultural counseling. They can't graduate without going through classes on it. It's not even a requirement, of course, in most law schools. It's something that's voluntary that we have integrated into our program at BC, and certainly that many other clinicians have as well.
And how many other law schools integrate that into their program?
I don't know the number. I think a lot of us do. We don't always call it explicitly multicultural lawyering because at the same time, being attentive to a client's specific circumstances is really good lawyering. It's just that with cultural differences, we're looking at a specific aspect of very good lawyering. And indeed, if you're a social scientist, you're going to say, a counselor, for example, that every single counseling encounter is a cross-cultural encounter because all of us bring our own specific cultural identifications with us. And even if we were both Taiwanese Americans, there would be differences probably in how we identify as Taiwanese Americans that would make it wrong for us to assume certain things about each other. I mean, it's not just that a white American lawyer with an Asian American client are going to have cultural differences. There can be cultural differences that occur within a cultural group as well. So multicultural lawyering, multicultural counseling really is about trying to be as accurate as possible in understanding your client's situation, including the cultural identifiers and cultural problems.
I see. So as I understand it, it's really about communication and accuracy in verifying that what you understand from your client is really the case.
Right, that they are saying, what you're hearing and interpreting from them is what they're intending to say to you. And then also, as we talked about, that you are then transmitting that information accurately, or at least as according to your client's instructions to the larger audience.
I see. And actually, our caller, I think, brought up an interesting issue about access to legal services. And I was wondering if I could get your thoughts on whether or not this teaching of multicultural knowledge with respect to client counseling for attorneys in any way impinges upon the access to legal services that Asian Americans might face.
It absolutely does. There's certainly a perception of the court system as being a whites-only court system. First of all, if you are a new immigrant, or even if you aren't and English is not your first language, it can be very hard getting into the courts, getting assistance with filling out forms. Our students who are going through law school, they're in their second and third year of law school, have trouble sometimes filling out the pro se or court-generated forms. And they're trained in this. So imagine being a non-lawyer going into family court and trying to figure out a complaint for divorce. And then add into that the language difficulties. If Khmer is your first language and there isn't even a form that's available in your language, okay, what do you do? So if we as lawyers don't recognize the expectations, the assumptions about the legal system that our culturally different clients bring to the table, we're not going to be able to help them. If we can help them, we're in some way serving as a legal interpreter, a liaison between the client and the court system. And the more accurately we can understand what their legal problems are, what their view of solutions can be, then the better able we're going to be able to help them figure out whether court's the right forum, and then if that is the right forum, how to work their way through it. And it's not just about language then, it's about understanding the culture as well.
It's an interesting way to put it. It's not just focusing on one aspect of cultural identity.
Exactly. And I do think with Asians in particular, again, language is a big one because there are so many different Asian languages in the Boston area now. We are seeing such an upswing in different Asian ethnicities coming into this area. Certainly getting an interpreter sometimes for the right language is a problem. As a lawyer, you have to start by identifying the correct language. Okay, if you have a client from China, do they speak Cantonese? Within Cantonese, is that Toisanese or some other dialect? What about Mandarin, Taiwanese? Okay, did we just identify it right? And then, did the interpreter come through with the right languages?
Right. Well, as we can see, it's a burgeoning field.
Right.
Multicultural lawyering. Oh, thank you so much for being on the show, Karwina.
Well, thank you so much for having me.
This is LegalLine with the Asian Lawyers Association of Massachusetts. I'm Ingrid Schroffner, and this is our first show. Thank you so much for joining us.
Thank you.